Good morning. It is 10 a.m., March the 12th, 2013. It is my privilege to call to order the meeting of the Department of Commerce and Insurance Board of Funeral Directors and Embalmers. At this time, I'll ask Ms. Lisa Mosby to call the roll, please.
Wayne Hinkle.
Here.
Tony Highsmith.
Here.
David Neal.
Here.
W.T. Patterson.
Here.
Jane Gray Sowell.
Here.
Robert Starkey.
Here.
Anita Taylor. Mr. President, everybody's accounted for except for Ms. Taylor.
Meeting will proceed. We'll ask you to please take a moment, look over the agenda as presented, and Chair will entertain recommendation on that.
President, I move to approve the agenda as presented.
Second.
Seconded by Ms. Sowell. Motion is made by Ms. Sowell, seconded by Mr. Neal to approve the agenda as presented. All in favor, say aye.
Aye.
Any opposed? Motion carries. Ask you would now to please look over the minutes from the February 12, 2013 board meeting.
Move approval of the minutes.
Second. Motion has been made by Ms. Sowell, seconded by Mr. Hinkle to approve the minutes as presented. Any further discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries. Scribble, would it be appropriate for somebody on your staff maybe to contact the other office and see if Ms. Taylor would be, and maybe in the other location,
Be glad
as far
to
as
do that.
the conference room, if we could do that, please. We will continue. We'll now have our legal report. Mr. Benton McDonald, Assistant General Counsel. Turn the meeting over to him.
Thank you, Mr. President. The first complaint today is case number 2012024161. On October 11th,
Would you pause just a moment,
Okay.
please, and let us get on the same page with you? Everybody on page and ready to proceed? Go. Okay. Counsel?
thank you, Mr. President. The first complaint is case number 2012024161. On October 11th, 2012, a field representative conducted a routine inspection of the respondent establishment. It was determined that the respondent failed to provide a description of the merchandise selected on 6 separate occasions on the statements of funeral goods and services selected. Furthermore, it was discovered that this omission seemed to take place when the family selected a service that included cremation. In response, the respondent states that they have contacted the proper officers in the company to address the glitch in their computer programs utilized by the company, and that the respondent will type in the required merchandise description until this matter is resolved. As you can see, they have one prior closed complaint, and we are recommending a letter of warning in this case.
Motion to accept council's recommendation.
Motion made by Mr. Hinkle, seconded by Mr. Patterson to accept council's recommendation. Any further discussion? All in favor say aye.
Aye.
Any opposed? Motion carries.
Number 2 is case 2012024-491. The complainant states that her husband's body was embalmed by the respondent without her permission. The decedent did not wish to be embalmed and asked that his wife have him cremated. The complainant states that she informed the respondent that she wanted her husband to be cremated when the respondent came to retrieve the decedent's body at the hospital, but she found that he was embalmed when she met with the employees with the funeral director at the funeral establishment to discuss funeral services, which cost her an additional $625. The respondent states that they were not aware of the complainant's request that the decedent not be embalmed. The respondent sent their embalming company to remove the decedent's body from the hospital, and the complainant never mentioned opposition to embalming. When the complainant met with the respondent to discuss final arrangements, the complainant mentioned her husband did not wish to be embalmed. However, the respondent claims that the complainant took blame for the miscommunication after the respondent apologized for the mistake. The respondent states that the complainant nor her daughter ever complained about the services provided, and the respondent has even agreed to deduct the $625 charge from the bill. We found 5 closed complaints in this case, and we're recommending a consent order with a $500 civil penalty and authorization for a hearing.
Second.
Motion been made by Mr. Patterson, seconded by Mr. Hinkle to accept council's recommendation. Is there any further discussion? All in favor, please say aye.
Aye.
Any opposed? Motion carries.
Number 3 is case 2012025-951. Excuse me. The complainant's brother purchased pre-need services with the respondent, and in 2010, the brother's health began to decline, and he asked that the contract be transferred to a local funeral establishment. The respondent informed the complainant that they would send the money once the appropriate paperwork was provided verifying the brother's death. The brother died on June 7, 2012, and the complainant states that they have received one excuse after another from the respondent, as no payment was made toward the $5,915 contract as of October 30, 2012, when the complaint was filed. The complainant further states that the respondent informed her that had the services been performed by the respondent, they could have provided up to a $10,000 funeral. Respondent states that in 1975, the decedent and his wife purchased 2 funeral services for the total price of $1,298. This included 2 caskets and 2 vaults. Additionally, the 2 purchased 2 interment rites, 2 opening and closing services, and 2 bronze memorials for a total price of $1,298 from the cemetery. The wife passed away in 2000, and the decedent utilized the pre-need contract from the respondent. The decedent died in 2012, and his family asked that the respondent provide payment for the portion of the pre-need contract. The decedent's family was mistakenly told to purchase opening and closing services and a concrete outer burial container for the price of $2,065.22, which were already purchased in 1975. However, that money was later returned after the error was found. The respondent then provided a check in the amount of $649 to the decedent's family for his portion of the pre-need funeral contract purchased in 1975, and the respondent explained that they purchased the establishment out of receivership, where the trust funds had essentially accumulated no earnings. Respondent would like to point out that they did provide the vault to the decedent, even though their refund of 100% of the amount of the pre-need contract included the price paid for the vault. Respondent believes that they have satisfied their obligations and declined the request to reimburse $5,915 to the complainant. We found a history of 7 closed complaints against this respondent, and we're recommending to dismiss this case.
So the respondent simply refunded the initial cost of the pre-need, is that correct? That's the way it appears,
Yes,
without any growth over that period of time.
right, because as they explained, there was very little growth.
President, this is an unusual situation. As Mr. McDonough says, this funeral home was purchased out of receivership, and in addition to refunding the one half of the original amount, they also furnished an outer burial container because the decedent was buried in their cemetery. It's a combination operation.
Make a motion to accept council's recommendation.
Motion made, Mr. Starkey, seconded by Ms. Sowell to accept council's recommendation. Any further discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries.
Number 4 is case 2012026821. On November 7th, 2012, a field representative conducted a routine inspection of the respondent establishment. One cremation authorization form was not signed by a funeral director. Also, the license and latest inspection report of the crematory utilized by this establishment were not available for inspection. And this establishment does not offer immediate burials per the price list, only direct cremations. However, decedent Walter Lee Jr. received an immediate burial according to his statement of funeral goods and services selected. The respondent states that the licensed funeral director signed the copy left with the crematory but failed to sign the copy retained by the respondent and states that this will not happen again. Respondent states that the license and latest inspection report were both present at the funeral establishment and that this violation was not noted on the original violation. Respondent states that they were trying to do a good deed by providing services at a greatly discounted price for a family with very little money. Respondent states that the family of Walter Lee Jr. had very little money and the respondent was able to find a cemetery to provide burial at a discounted price. Respondent provided immediate burial, however, this service is not listed on the general price list. We found no history of prior complaints, and we're recommending a consent order with a $250 civil penalty and authorization for a hearing.
Is it immediate burial on the general price list? Isn't it one of the things required by one of the items?
It is required if the firm provides it, but heretofore, this firm had not provided an immediate burial.
Oh, okay. It seems to me they didn't know, if they're not required to do that, they did no wrong. I don't understand the penalty.
It's because they offered something that they didn't state on their price list. So it wasn't on their price list, and they offered it, and it wasn't on their price list. So they offered
did it to accommodate the family. I mean, we all have circumstances, like that. When you're trying to help a family, it seems like they're punishing them for doing something good.
Make a motion we accept council's recommendation.
Motion has been made by Mr. Neal, seconded by Mr. Patterson to accept council's recommendation. All in favor, say aye.
Aye.
Any opposed?
Hey,
Okay.
No, I'll vote no.
Ms. Mosley, let's have a roll call vote, please.
Wayne Hinkle,
yes, accept.
Tony Highsmith,
Yes.
David Neal,
Yes.
Debbie T. Patterson, Jane Gray Sowell,
No.
Robert Starkey,
No.
Miss Anita Taylor.
Ms. Taylor, do you wish to pass on? Ms. Taylor passes. So the motion carries. We have just finished complaint number 4 and are moving to complaint number 5. Ms. Mosley, let the record show that Ms. Taylor has will now be a part of the discussion from this point forward. Good morning, Ms. Taylor. Good morning. Mr. Counsel, item number 5, please.
Number 5 is case 2012026-861. Number 6 is case 2012026-862. And number 7 is case number 2012026-863. On November 6, 2012, a field representative conducted a routine inspection of the respondent establishment. The license and latest inspection report of the crematory utilized by this establishment was not available for inspection. The funeral directors and embalmers license of respondent number 6 and number 7 expired on September 1, 2012, and was not renewed until September 23, 2012. Respondent number 6 and number 7, this individual was the funeral director in charge for 6 funeral services during the period of time in which that individual had no current license, funeral director's license. Also, respondent number 6 and number 7 was employed by respondent number 5 during this time that the funeral director's and embalmer's license was invalid. In response, the respondent states that they thought that they had provided the field representative with copies of all appropriate documents, but they have since provided the license and latest inspection report for the crematory. As for respondent number 6 and number 7, this individual believed that his license expired at the end of September, but admitted his oversight and contacted the board office as soon as possible. The respondent believed that he was allowed to keep practicing after making the phone call and submitting his paperwork until he received a letter to cease practicing on September 25th of 2012. In this case, respondent 5 has 1 prior closed complaint, and we found no prior complaints for respondent number 6 or number 7. And we're recommending for respondent number 5 a consent order with a $250 civil penalty and authorization for a hearing. And respondent number 6 and number 7, which is the same individual, we're recommending a consent order with a $250 civil penalty and authorization for a hearing. A total civil penalty of $250 in that case.
As renewed.
Yes.
Pause and
Yes, ma'am.
Motion has been made by Mrs. Sowell, seconded by Mr. Neal to accept council's recommendation. Any further discussion? All in favor, say aye. Aye. Any opposed? Motion carries.
Number 8 is case 2012026-891. On December 6, 2012, a field representative conducted a routine inspection of the respondent establishment. From the date this crematory began operation on October 18, 2012, they have provided cremation services for 45 human remains. However, none of the urns provided in these cases contain the identification device required by state law. Respondent also failed to maintain a separate record containing the location, date, and manner of final disposition by the crematory of the cremated remains. Furthermore, these records were not maintained for any of the 45 human remains. Respondent failed to record the name of the funeral home, cemetery, or other entity to whom the cremated remains were released for Alice Brown and Martin Lerna. The respondent states that the respondent placed the numbered round disc which matched their records in the urn with the cremated remains for identification purposes. They immediately corrected the mistake and are now placing the identification devices required by law in the urn and did not perform another cremation until they had the proper identification devices. Respondent is now keeping a separate record as defined by law, and respondent states that as for the 2 cases where no record was kept regarding who took possession of the cremated remains of the cremains for Alice Brown and Martin Lerna, they were released to a specific funeral home, not a family member, and the funeral home was noted in their specific records. We found no history of prior complaints, and we're recommending consent order with a $500 civil penalty and authorization for a hearing.
45 human remains in urns that was not, they have a numbered round disc.
Yeah, that's correct. They apparently had a disc that corresponded with the records that they were keeping, and that does not meet the specifications.
Motion to accept council's recommendation.
Motion is made by Mr. Hinkle, seconded by Mr. Patterson to accept council's recommendation. Any further discussion? All in favor say aye.
Aye.
Any opposed? Motion carries.
Number 9 is case 2013000451. Number 10 is case 2013000452. And number 11 is case 2013000453. On April 23, 2012, a field representative conducted a routine inspection of the respondent establishment. It's determined that the funeral director's license of respondent number 10 expired on June 30, 2010, and had not been renewed at the time of the inspection. Respondent number 10 signed as the funeral director on 3 statements of funeral goods and services selected at that time period. Respondent number 10 also serves as the manager for respondent number 9. Therefore, there was no licensed funeral director serving as manager for respondent number 9 at the time of the inspection. Respondent number 11 is the owner of respondent number 9 and signed 2 statements of funeral goods and services selected in the capacity of a funeral director. However, the individual is not a licensed funeral director. In response, respondent states that a new manager was put in place for respondent number 9 on May 11th, 2012, and this manager states that she has no knowledge of anything that occurred prior to May 11th, 2012. Respondent number 11 states that he apologizes for his employee's funeral director's license lapsing and states that changes have been made to prevent incidents like this from happening again in the future. Furthermore, respondent number 11 provided a copy of a check he states that he provided to respondent number 10 in 2010 to renew her license. Respondent number 9 had 2 prior closed complaints, and respondents number 10 and number 11, neither of those individuals had prior complaints. For respondent number 9, we're recommending a consent order for $500 civil penalty and authorization for a hearing. Respondent number 10, we're recommending a consent order with a $300 civil penalty and authorization for a hearing. And respondent number 11, we're recommending a consent order with a $250 civil penalty and authorization for a hearing.
Respondent number 10's license were expired for nearly 2 years,
That's correct.
and then are they licensed now? Do we know? So they would have exceeded all of their renewal opportunities, and the license would have lapsed then, correct?
She's currently no longer the manager there at that establishment. So
Often are they inspected during?
I don't know, but she's not the manager there, and hasn't been for some time.
I mean, was there a 2-year gap in between inspections?
No.
So it just wasn't noticed before that they were unlicensed?
You might have been a manager at that time.
It says in 2006 there was a complaint due to unlicensed activity, and they were fined $1,000 then.
Only signed apparently 3 funeral goods and services during that almost 2-year period.
that's correct.
So So is it a very small firm, or is just this director not meeting with that many families?
Is the owner's the one that's unlicensed, and the owner signed the statement of funeral goods and services?
The owner signed as a licensed funeral director on 2 statements of funeral goods and services selected, so.
This inspection was done April 23rd, 2012. In 2011, this firm had 4 calls, and one of those was a cremation. And their calls year-to-date for 2012, when the inspection was done, was 0. So it's a very small,
Were they licensed then?
Licensed establishment.
licensed establishment, yes.
Was licensed?
Yes, a licensed establishment, a non-licensed owner, and a
Unlicensed funeral.
funeral director who was a manager whose license had expired. What had happened is my understanding that this funeral director whose license expired was no longer there, but the firm had not yet replaced the person with a licensed funeral director. Death certificates were, and they're actually not signed, it's typed in, so it's not the funeral director's signature, but her name and license number is there. Dates of death are April 20, 2011, June 10, 2011, and September 10, 2011.
Well, how can the firm have an establishment license if they don't have a listed licensed manager?
It's 2 separate licenses. The establishment has a license. That's why you have the complaint before you today, is because the manager was not licensed. But it doesn't, the complaint is against the funeral home, the person who was the individual funeral director who is no longer licensed, and the non-licensed owner, because the non-licensed owner had also signed documents. Let's see what date they were signed.
But did they have an establishment license during that period?
Yes, they did.
How was it valid if they didn't have a licensed manager, is my question.
It has nothing to do with the validation of the establishment license. It can be a complaint because they weren't meeting the requirements, but it doesn't do anything to affect their establishment license, other than you can take disciplinary action against them for not following the laws, rules, and regulations. But it doesn't automatically suspend their establishment license, or it doesn't revoke it or anything because they fail to have a manager.
Just maybe to clarify Mrs. Sowell's question, if an establishment license comes in and it shows John Doe, license number XYZ, as the manager of that establishment, is that manager's license checked to make sure it's a valid license before the establishment license is either, before it's renewed?
Motion to accept council's recommendation.
Motion has been made by Mr. Hinkle, seconded by Mr. Patterson, to accept council's recommendation. Is there any further discussion? Would it be practical to believe that if number 10 is no longer practicing, that penalty would never probably be, that $300 penalty would probably never be paid? However, if that individual came back in the future to get a new application, would this be noted with that individual funeral director?
It would be flagged,
Okay.
and if it were not collected, then it could be a good sign that they would not, the next board would not give them a license.
Any further discussion? I have a motion on the floor that has been duly seconded. All in favor, say aye. Aye. Any opposed? Motion carries.
Number 12 is case 2013000461. On April 11th, 2012, a field representative conducted a routine inspection of the respondent establishment. The respondent's license expired on March 1st, 2012, and was not renewed until March 11th, 2012. During this time, the respondent conducted 5 funeral services on an expired license. Furthermore, it was discovered that the respondents failed to provide appropriate wording for the basic service fee on their general price list. The respondent admits that they were at fault and paid to renew their license as soon as they were notified of the lapse, and the respondent enclosed a corrected copy of the general price list to include the wording of basic services basic services of funeral director and staff. We found a history of one closed complaint, and we're recommending a consent order with a $500 civil penalty and authorization for a hearing.
Recommendation, we accept council's.
Made by Mr. Starkey, it's been seconded by Mr. Hinkle to accept council's recommendation. Is there any further discussion? All in favor say aye. Aye. Any opposed? Motion carries.
Number 13 is case 20130000511. On May 1st, 2012, a field representative conducted a routine inspection of the respondent establishment. The respondent's latest inspection report for crematory utilized by the respondent was not available for inspection. Also, the cremation authorization forms state that the respondent has to wait 120 days before interring unclaimed remains, but that is in violation of the statute, which reads 180 days. The current funeral director's license for 2 employees is not available for inspection. The current establishment license was not available for inspection, and on 5 statements of funeral goods and services selected, the merchandise and its description was not included in the statement of funeral goods and services selected prior to the customer signing the document. Respondent states that they were unaware that the crematory's most recent inspection report must be maintained by the funeral home, but this oversight was corrected. The respondent admits to cremation authorization forms including 120 days instead of 180 days, and this matter has been addressed. The current funeral director's license for these 2 individuals has since been posted along with the establishment license, and the customer was in possession of the general price list at the time that they signed the statement of funeral goods and services selected. However, the respondent states that they will provide a description of the merchandise selected from this point forward. We found a history of 4 closed complaints and 1 dismissed, and we're recommending a consent order with a $500 civil penalty and authorization for a hearing.
Make a motion.
Second.
Motion has been made by Mr. Patterson, seconded by Mr. Starkey to accept council's recommendation. Is there any further discussion? All in favor say aye.
Aye.
Motion carries. I'm sorry. Were there any opposed? I did not. Motion carries.
Number 14 is case 20130000531. On May 8th, 2012, a field representative conducted a routine inspection of the respondent establishment. The respondent had several violations concerning their general price list, their casket price list, and the statement of funeral goods and services selected. On the general price list, the basic service fee disclosure was incorrect. The use of equipment and staff for graveside services must be added. The casket price list disclosure must be added. The outer burial container price list must be added, and the alternative containers with prices must be added. On the casket price list, 1 casket in the casket selection room was being offered to the consumer, but is not listed on the casket price list. And on the statement of funeral goods and services selected, the reason for embalming was not addressed on 2 contracts. The respondent admits to the violations and made the corrections while the field representative was present. Respondent provided corrected copies of those documents to council, and we found a history of 4 closed complaints, and we're recommending a consent order with a $500 civil penalty and authorization for a hearing.
Second.
Motion's been made by Mrs. Taylor, seconded by Mr. Starkey to accept council's recommendation. Any further discussion? All in favor say aye. Aye. Are there any opposed? Motion carries.
Number 15 is case 20130000571. On May 14th, 2012, a field representative conducted a routine inspection of the respondent establishment. The co-owner of the establishment had their name listed as co-owner on the establishment material without indicating that they were unlicensed. The establishment name listed on the establishment application is different than that advertised on the vehicle's website and memorial folder. Errors with the general price list. The casket price range was incorrect when compared to the casket price list. The outer burial container price range was incorrect compared to the price of outer burial container price list. The immediate burial with Gemini 20-gauge non-sealer was not listed on the casket price list. The direct cremation must include the range, and direct cremation with corrugated cardboard container price was incorrect compared to the casket price list. On the statement of funeral goods and services selected, one customer chose the memorial with cremation arrangements. She was charged $1,995 for basic services of funeral director and staff, and $250 for transfer of remains to the funeral home, both of which were already included in the package, creating an overcharge of $2,245. One customer chose the memorial with cremation arrangements. He was charged $1,995 for basic services of funeral director and staff. This was already included in the package, and staff also charged for corrugated cardboard container and rental casket. The rental casket includes charges of insert, creating an overcharge of $2,245, but the respondent waived $823.12, leaving an overcharge of $1,421.88. Also, one customer chose funeral with cremation arrangements. He was charged $1,995 for basic services of funeral director and staff, which was already included in this package. The respondent charged for corrugated cardboard container and additional charge for rental casket. The respondent charged the family $250 for transfer of remains to funeral home. All of this resulted in an overcharge of $2,697 with a discount of $2,200, leaving a net overcharge of $497. Also, one statement of funeral goods and services selected does not provide a reason for embalming when a fee was actually charged. And we received no response in this case, and we found a history of one open complaint and one closed complaint, and we are recommending a consent order with a $3,000 civil penalty and authorization for a hearing.
Does that include the $250 because they didn't respond?
Actually, it does not. That's a good point. I will add that.
The 250 needs to be added to the 3,000 then. Right.
So it'll be $3,250.
But no response.
Since they haven't responded, we don't know whether they've credited that amount back to each family in each case.
That's correct. But I will add that on to the consent order that they provide verification that they did refund that money.
Motion to amend the consent order from $3,000 to $3,250 and authorization, civil penalty and authorization for a hearing.
Deal with that motion.
Second on my
Second it.
There's been a motion made by Mr. Hinkle, second by Mr. Starkey, to accept council's recommendation with an increase in the consent order from $3,000 to $3,250 civil penalty and authorization for a hearing. Is there any further discussion? Council, would that, you had mentioned addressing the situation with the overcharge on these three families. Would that be automatic in your response, or does that need to be handled here today?
You may want to just read it into the record, but I always make sure that they provide verification that the refunds were made. Although I will also add, though, that I usually inform them that we cannot, obviously force them to refund the money. We just tell them that it would be in their best interest we believe, to refund the money in that case. That would have to be a civil matter that the individual would have to bring against the establishment in order to get that money back.
That condition.
No. I usually add that into the cover letter to let them know that it would be in their best interest to provide that refund.
Now, if they decide not to, the next thing would, before this board would see this again or something similar to this, would have to be the actual person that was overcharged to file a complaint.
Obviously they can file a complaint, but, we are not here to be able to obtain that refund for them. It's a civil matter that they would have to, if they decided not to refund the money, then, the customer would have to hire legal counsel and, bring a suit against them in civil court.
Wouldn't be unprofessional conduct by overcharging you customers.
I'd have to review it a little closer, but I think you could always, that's a pretty broad
I understand that.
area, so.
I understand that.
And how would the work?
It looks like in this case that they probably are not aware of that, and that's why we bring it to the attention of the funeral establishment, that that's something that they need to address and that they need to provide that refund to the individual. But we don't have any authority to force them to do that.
You have the authority to notify the consumer.
I would do that if they didn't provide any sort of response to us showing that they provided the refund to them. So we'll make sure that the consumer is notified of that.
Understand I was going, but I'm not going to go there today. Let's see how this motion.
They have 30 days to respond. Fine, that is the civil penalty that is imposed, correct?
Yes, ma'am. It's 30 to 45 days.
30 or is it 45?
30 to 45 days. We give them that time. Yes, ma'am.
The window.
You're supposed to respond within 30 days, but we do allow them.
15-day grace period.
Right.
Is there a reminder at that point?
There's a phone call that I will make to
The end
them
of 30 days.
to let them know that time's run out.
Any further discussion? That being heard, we will call for the vote on the recommendation of a consent order with a $3,250 civil penalty and authorization for a hearing. All in favor, say aye. Aye. Any opposed? Motion carries.
Number 16 is case 2013000641. On May 15th, 2012, a field representative conducted a routine inspection of the respondent establishment. On the general price list, under immediate burial, the high-end range is inconsistent with the casket price list. Also, the immediate burial with minimum thickness, non-protective metal casket selected from the funeral home price is inconsistent with the casket price list. Under direct cremation, the high-end range is inconsistent with the casket price list. Under direct cremation, the casket selected from the funeral home price is inconsistent with the casket price list, and the high-end range on the outer burial container price list is inconsistent with the casket price list. Also on the casket price list, there are 3 caskets in the casket selection room that are offered to the public but not listed on the casket price list, and that's the Liberty Veteran 20 gauge, the Mirror Black 18 gauge, and the Blue Polaris 20 gauge. Also, 2 caskets in the casket selection room are offered to the public but are inconsistent with the casket price list. That's the Coral Mist Comfort for 18 gauge for $2,995 listed on the casket price list, and it's actually listed for $2,495. And then the Nutmeg Brushed 18 gauge is listed at $2,695 on the casket price list, but is also listed at $2,495 in the casket selection room. On the statement of funeral goods and services selected, the statements of funeral goods and services selected for 5 individuals lacked a reason for embalming. And on the cremation authorization form, one cremation authorization form lacked a funeral director's signature. In response, the respondent states that they're upset because the establishment was in the midst of renovating the selection room and setting up new price lists. The respondent admits that he may have forgotten to provide the reason for embalming on several statements of funeral goods and services selected. However, he states that the field representative apologized for coming in at such a stressful time. The respondent has since sold the business, and we found a history of 2 closed complaints, and we're recommending to close this case since it is now under new ownership.
Recommendation.
Motion has been made by Mrs. Taylor, been seconded by Mr. Patterson to accept council's recommendation. Is there any further discussion? All in favor, say aye. Aye. Any opposed? Motion carries.
Number 17 is case 2013000671, and case number 18 is case number 2013000691. On May 16, 2012, a field representative conducted a routine inspection of the respondent establishments. On the casket price list under immediate burials, the high-end range is inconsistent with the casket price list. On the general price list under immediate burials with cardboard container, the price is inconsistent with the casket price list. And on general price list under direct cremation, the high-end range is inconsistent with the casket price list. The pricing made by the casket price list, alternative container of $125, plus the direct cremation of $1,550, the service costs of $1,675. However, the consumer is being charged an additional $50 due to the inconsistency of the 2 lists, and 26 consumers were found to be overcharged by $50, creating an overcharge of $1,300 combined. The respondent admits that there were errors in their pricing regarding the general price list. The respondent states that they went back and reviewed all of the contracts made and made $50 refunds to the families affected by the overcharge. And by May 25, 2012, respondent provided refund checks to all of those families. We found a history of 1 closed complaint in this case, and we're recommending for respondent number 17 a consent order with a $250 civil penalty and authorization for a hearing, and for respondent number 18 a consent order with a $250 civil penalty and authorization for a hearing.
Motion to accept council's recommendation.
Second.
Motion made by Mr. Hinkle, seconded by Mr. Neal to accept council's recommendation. Any further discussion? All in favor, say aye. Aye. Any opposed? Motion carries.
Number 19 is case 2013000721. On May 23, 2012, a field representative conducted a routine inspection of the respondent establishment. It was determined that 1 body was dressed, casketed, and ready for viewing. However, the body had a permanent identification device that was incomplete with the date of birth, date of death, and social security number missing. Furthermore, in the statement of funeral goods and services selected, the field representative found 5 of the statements of funeral goods and services selected lacked a listing of the merchandise and description of the merchandise, which should have been available to the customer prior to signing the contract. Respondent states that the social security number had not been provided to the respondent at the time that the inspection took place, but was later provided and placed on the identification device prior to visitation taking place. Furthermore, respondent states that the customer is always in possession of the general price list at the time that they sign the contract, and this document provides the appropriate description and listing of merchandise. However, the respondent is now aware of the requirement that the merchandise be listed with a description on the statement of funeral goods and services selected prior to the customer signing the document, and has taken steps to address this issue in the future. We found no prior complaints, and we're recommending a consent order with a $250 civil penalty and authorization for a hearing.
Council's recommendation.
Second.
Motion has been made by Mrs. Taylor to accept council's recommendation, seconded by Mr. Starkey. Is there any further discussion? All in favor, say aye. Aye. Any opposed? Motion carries.
Number 20 is case 2013000771. Number 21 is case 2013000772. And number 22 is case 2013000773. On January 8th, 2013, the board received a complaint regarding this matter. The complainant states that he provided assistance at all 3 locations from 2007 through 2012. The complainant states that the following work took place at the location for respondent number 20. This individual helped load and unload a deceased individual for $1,500. He did carpentry work at the funeral home for $800 and cleanup for $650. Respondent number 21, at this location, the complainant helped load and unload a deceased individual for $1,200. And at the location for respondent number 22, the complainant provided concrete work for $650 and then loaded and unloaded deceased individual on 3 occasions for a total cost of $450. In response, the respondent believes that these complaints are frivolous. Respondent owner and complainant were in a relationship which ended 2 years ago. The respondent does not recall the complainant ever providing any services alleged in the complaint at any time. However, respondent cannot clearly recall whether the complainant may have assisted in loading and unloading a body once at the location for respondent number 21. And the individual states that the 2 parties were in a relationship at the time, but they do not recall the complainant ever providing that service at any of the 3 locations. The respondent believes that the complainant has a vendetta against the respondent owner and asks that these complaints be dismissed. For respondent number 20, we found a history of 1 closed complaint, respondent 21, a history of 6 closed complaints, and respondent number 22, a history of 4 closed complaints. And our recommendations for respondent number 20, 21, and 22 are that all 3 cases be dismissed.
What exactly is the,
He was not paid for his services.
oh, he was not, oh.
Right, that's correct.
$100 just to help them unload 1 body. Motion to accept council's recommendation.
Second.
Motion is made by Mr. Hinkle, seconded by Mrs. Taylor to accept council's recommendation. Any further discussion? All in favor say aye. Aye. Any opposed? Motion carries.
Number 23 is case 2013000751. On May 29th, 2012, a field representative conducted a routine inspection of the respondent establishment. These findings included for the outer burial container price list, the disclosure on the price list was incorrect. On the general price list, the use of facilities and staff for memorial services must be added. Under immediate burial with cloth-covered casket, the price is inconsistent with the casket price list. The high-end range for outer burial containers is inconsistent with the casket price list. The outer burial container price list disclosure is incorrect, and the casket price list disclosure is also incorrect. The current funeral director's license for the manager and another employee were not available for inspection. The current embalmer's license for the same 2 employees were not available for inspection. The wife of the owner was listed on the establishment website as a 3rd-generation funeral director. However, she is not a licensed funeral director. The establishment's pre-need seller registration became invalid on March 31st, 2012, and was not renewed by the date of the inspection. A funeral director failed to sign the cremation authorization form from the decedent, Martin Peterson. Also, the cremation authorization forms were not retained in the customer's file on 1 occasion, and the license of the crematory utilized by this establishment was not available for inspection. And other violations in the preparation room, the ventilation fan was not in operating condition. The last embalming was performed on May 26, 2012, and the room was not cleaned 3 days later, as bloody soiled towels and linens were left on the counters. Also, the field representative found open makeup used on the last deceased body that was left scattered on counters uncovered. We received no response in this case, and we found a history of 2 open complaints, 3 closed complaints, and 1 dismissed complaint. And we're recommending a $3,000 civil penalty plus $250 for no response, for a total civil penalty of $3,250 and authorization for a hearing.
Make a motion to accept council's recommendation.
Second.
Motion has been made by Mr. Starkey, seconded by Mr. Patterson to accept council's recommendation. Is there any further discussion? All in favor, please say aye. Aye. Any opposed? Motion carries.
Number 24 is case 2012019391. This was a case that was previously presented. The complainant is a competitor of the respondent establishment. The complainant received a phone call from the local Alive Hospice regarding an individual who had just passed away. The complainant and an assistant went to the hospice to meet with the family and obtain permission to embalm the decedent. The family met with the complainant and discussed funeral arrangements, including that they wanted the decedent buried on the grounds of the respondent establishment. The complainant contacted the respondent and informed them of the family's wishes that their loved one be buried on the premises and set up a meeting between the respondent and the family for that afternoon. As the complainant was leaving work later that afternoon, he received a message from an employee of the respondent establishment informing him that the family wished to transfer final arrangements to the respondent funeral establishment. The complainant contacted the family and the respondent and found that the respondent promised to provide funeral services and burial for the cost of the insurance policy that the family had in their possession, which was a total of $10,000. The complainant alleges that the respondent quoted a price initially of $14,000 for the funeral and burial, but then called in two employees who were not licensed funeral directors to negotiate with the family to come to a cost of $10,000. The complainant states that the cost they quoted for the funeral alone would be in excess of $8,000, and the cost of burial at the respondent establishment would put the price in excess of $10,000. So the family decided to use the services of the respondent for $10,000. The complainant believes that the respondent took advantage of the family at a time of need and used unlicensed personnel to make the final arrangements. In response, the respondent believes they did nothing wrong or unethical, as the complainant alleges in this case. The respondent states that the family was quoted over $8,000 for the funeral services at the complainant's establishment, and that the cost of the burial with opening and closing alone would put the cost over $10,000. Also, respondent states that an unlicensed employee is aware of the law and did not quote the family a price at the respondent establishment, but contacted a licensed funeral director to discuss what could be done for the family. The respondent manager told the employee that they could work with the family and cover all the final arrangements for $10,000. The manager asked the employee to call the other manager who had put in his 1-month notice at that point and ask him to assist with the family. The other manager told the employee to ask the family to come back the next day so they could meet with a licensed funeral director. The employee informed the respondent that the family had never signed a contract with the complainant's establishment. This case was originally presented on November 13th, 2012, and the board issued a consent order with a $1,000 civil penalty. Council has conducted further research, including a conversation with the respondent, and determined that there was no violation in this case, and that the unlicensed personnel did not actually meet with the family and did contact a licensed funeral director, who then came in the next day and met with the family at that point. We found a history of 2 closed complaints and 1 open complaint. The original recommendation was a consent order with a $1,000 civil penalty and authorization for a hearing, and our new recommendation is to dismiss this case.
Make a motion we accept council's recommendation.
Second.
Motion has been made by Mr. Starkey, seconded by Mr. Hinkle to accept council's recommendation. Is there any further discussion?
Is there anything that was like that? No written evidence.
Of the of unlicensed
Any of
activity.
There's nothing, you had nothing in writing but that bore witness to this, or to validate this complaint.
That's correct.
Did she say?
At this point, yes, ma'am. We had several conversations with the respondent in this case, and she did in fact assure us that she spoke with the unlicensed individual several times that day, and that individual was well aware that they were not to meet with the family and make any final arrangements or anything of that nature, and so that individual contacted the other licensed funeral director that was employed there and they came in and met the next day with the family. And so there was no, as far as we could tell, no unauthorized activity or unlicensed activity going on at that time.
Any further discussion? All in favor to accept council's recommendation to dismiss, say aye. Aye. Any opposed? Motion carries. Chair will now, thank you, Mr. Benton, for your report.
Thank you very much, Mr. President.
Chair will now recognize Mr. Robert Gribble, Executive Director, for administrative matters.
Thank you, Mr. President. The first is the licensee report, which is a report of licenses administratively approved by the Executive Director pursuant to the Board authority for the period of February 12, 2013 through March 11, 2013. You'll notice there's one new establishment and then several individuals who were licensed as funeral directors and embalmers are just as a funeral director. There were no closed establishments to report to you since our last board meeting. The disciplinary action is a report of the consent orders administratively accepted or approved by the Executive Director pursuant to the Board authority for the period of February 12, 2013 through March 11, 2013. Of course, the Board is aware of those first two because the Board themselves approved them. The third one listed is the only one that is actually information to the Board. Open complaint report. According to Ms. Mosby, as of yesterday, we had 116 open complaints, broken down to 0 against apprentices, 6 against funeral directors and/or embalmers, and 110 against establishments. Legislative report. This was emailed out to you earlier because I thought you might want to have that so that you could retain that. This is a list of legislative bill information that was current as of last Friday. You can see the different bill numbers, and at the very end there's a website that you can go to and type this bill number in and bring up all the information about that particular bill. The Senate Bill 0315, which extended the life of the Board of Funeral Directors and Embalmers till June the 30th, 2018, has passed through both chambers, both the House and Senate, and that's the bill that has the Fathers Movement. And then House Bill 1125, which, as introduced, allows the disposal of a human dead body through the process of alkaline hydrolysis. There's a presentation that some interested individuals have to make to you later regarding that bill. Those are probably the bills that also the removal service bill, which is Senate Bill 0416, requires persons to register owner after July the 1st, 2013 with the Department of Commerce and Insurance prior to operating a removal service that arranges, directs, supervises, or performs the transportation of human remains. That bill is seeing considerable movement as well. Those are the bills that are probably of most interest to this board. The others are there for your information because we know that even though part of them have to do with cremation in a very distant relationship where it has cremation, some of those is to do with county governments and saving costs so that they would be allowed to use cremation as a method of disposition instead of burial only. And we know that many of you either, well, you deal with the cemetery on a regular basis, so we also put the information there as far as as for cemeteries as well. And when you get to it, to to the presentation on alkaline neurolysis on your iPads is House Bill 1125 in its entirety, so that you can refer to that if you'd like to. Mr. President, that concludes my report.
Is there any question from the board regarding any of this legislative update, with the exception of House Bill 1125, and we'll discuss that during the presentation. Is there any questions or discussion about these other bills?
On the Senate bill and House Bill 0727, House Bill 0715, it talks about granting authority to coroner or county medical examiner. Talking with the State Forensic Center, she says that Tennessee is a medical examiner state only and not a coroner state. That there's only 3 coroners left in the state of Tennessee. That you are a medical death investigator under the medical examiner. And they were asking, could that word be removed as coroner and not give the coroner authority to cremate someone, only the medical examiner in the county?
You might want to suggest, Mr. Neal, that person contact the sponsor of the bill,
Okay.
which is Senator Watson in the Senate and Representative Carter in the House, and make that suggestion to them. It was set to come up yesterday in the General Welfare Committee of the Senate. I was up there at the meeting. Meeting lasts from 2:30 to 4:30 yesterday, and they ran out of time, so they were ready for this bill in that committee. They ran out of time, and they moved it to next week's calendar. So it'll be coming up. I'm not sure what day next week. They said it was unusual that they meet on Monday, so it'll probably come up on Tuesday or Wednesday of next week.
Thank you for pointing that out, Mr. Neal. Are there any other discussions about any of those other activities?
On the, Bill 416, registration with the Department of Commerce and Insurance. There's no licensing involved. It's just strictly a registration.
That's correct.
Will they receive a permit or identification?
They would receive
If I wanted to call somebody, what do they need to show me that they're registered?
Sal, it would be just like, it would be in a format similar to what your funeral director's license.
Something that we have from a crematory that
Yes.
we were to use.
It would be on the same type format, and it would just say whatever it passes in its final language, whether it's a removal service or a transport.
A copy of that registration in our files if we use them, correct?
Well, that would be to your benefit. It's not required by rule. The board would need to promulgate a new rule if the board wanted to require that. That would have to be done through rulemaking. But this bill gives the board authority to it's my recollection that the board has some rulemaking authority in the bill. One, to set fees, because there's no fee set for it, so the board would have to set fees.
If this bill is enacted in a funeral home, somebody to make removals that is not registered with the department, establishment violation. What is the violation?
course, it would depend on exactly how the law is passed. But it would appear that if an establishment did what you just mentioned, they'd be in violation of Rule 0660-11-11.03 regarding the use of outside services, where it says no funeral director, embalmer, or establishment shall utilize the services of an independent contractor, trade embalmer, or any other outside provider if the funeral director, embalmer, or establishment knows or reasonably should know that such independent contractor, trade embalmer, or other outside provider is in violation of any statute or rule pertaining to the board. That would,
Very clear.
Does this need to address families hauling bodies? We've had more and more families because so many airlines have gone to regional jets instead of bigger ones, so because of getting the body to a place, the family, of course, we give them barrel transit permits, but we've had a number of families, probably 3 or 4 a year that will haul the body in their own vehicle up north somewhere.
Well, I think at this rate right now, it's difficult to make a determination about how things are going to work out because we don't know how the bill is going to be passed in its final form yet. So until we know that for sure, I don't know that it would be in our best interest to speculate on what exactly how this law is going to apply until.
But this does say operating a removal service, so that would that not preclude a family from,
I don't think you can hardly keep a family from carrying.
if they wanted to do that themselves?
Well, like I said, I just think at this rate, we probably need to wait and see exactly, because I know that there have been several changes to this particular legislation, and I think at this point for us to speculate on what's going to be in the final form, would not be beneficial to this board at this time.
Also,
It
I
would be
might add
removals for profit.
that under the removal service definition, it says performing the transportation of human remains for a fee.
Yeah, this is operating a removal
Right.
service. I mean, we had somebody not long ago a family that this man had restored this truck, and it was just something, and we put the body in the back and fixed it where thing in there, take the body to the cemetery because that's what they wanted to do. This would not preclude.
In its current form, I don't believe that it would.
And if they want to transfer a body in their own van or truck, vehicle or something, we've had that happen, and it's just most times because they want to do it, and it does sometimes save money.
Legal if all dies and I put her in the pickup truck and bring her down to Debbie T's place?
Anything you can do about it.
I don't charge a fee, but if I start charging fees to pick up other people's grandma, then
And you would
this
fall
is
under
what
that?
this would be.
Right.
But it's kind of like hauling them in the truck or pickup truck or something like that. You put her in the rumble seat, won't you?
Keep on going.
Put her in the rumble seat. About that mule.
That answers my question.
I'm getting silly.
Dribble license applications, individuals and establishments. I'm sorry. Chair will entertain a motion to approve Executive Director's report on administrative matters.
Motion.
Moved by Mr. Patterson, seconded by Mr. Hinkle. All in favor, say aye. Aye. Thank you, Mr. Gribble.
thank you, Mr. President. As far as individuals, there are no individuals to appear before the board. There is one establishment to appear before the board today. It's Wise Choice Cremations, located at 2735 Highway 64, Suite 104 in Hickory, Wythe, Tennessee. Its ownership is a corporation owned by Fayette County Funeral Home Incorporated. It's a Tennessee corporation located in Somerville, Tennessee, and we have two gentlemen present today that can come forward and identify themselves and speak to the board regarding that particular application.
Gentlemen, you have addressed the microphone. Please state your names for the record, please.
Michael Tillman.
Paul Pratt.
Your association with what corporation or funeral home?
We're both funeral directors.
Mr. Tillman, if you would, while the board's looking through their information, is kind of explain to them. I know some of the board members were probably here last year when you came in August and obtained a license similar to this, but we also have a new board member, so you might give them a little information about what you're doing there.
Yes, sir. I believe August. Application establishment. Hyperton office. It is a facility that we primarily for prearranged funerals. Primarily that establishment was
As far as its location from your Oakland chapel,
approximately 7.
You are applying for an establishment license at 2735 Highway 64, Suite 104 in Hickory With, Tennessee. Will there be any embalmings take place at that location?
No, sir.
Will there be any cremations take place at that location?
No, sir.
Will there
Wise
ever,
choice.
will there ever be a deceased human body enter that location?
No, sir.
Will there be any public services, visitation, funerals, or anything of that nature at that location?
No, sir.
Pre-need or a funeral establishment office?
Pre-need, we can wait on pre-need and at-need families there in the facility, but we would contract out the embalming services and the cremation service.
The only thing on this price list are caskets and outer burial containers.
Maybe the other side of this wasn't loaded. It looks like it.
Because there's no charge for services. If they select a casket, there's no charge for services or
Be
anything
a
else.
complete price list.
Let you look at this one.
What happened was, in order to save the expense of the field representative driving it back in from West Tennessee, he scanned it and sent it to the office. Now, maybe he failed to scan a portion of it. But he did an inspection on March the 6th, and he has assured me that he has signed off that everything as far as the paperwork is in order as far as that part of it.
Make a motion, we approve this license, establishment license.
Been a motion made by Mr. Starkey to approve this establishment license, seconded by Mr. Hinkle. Is there any further discussion? All in favor, say aye.
Aye.
Any opposed? No. Ms. Mosley, let the record.
No.
I'm sorry, Ms. Mosley, let's have a roll call vote, please, ma'am.
Wayne Hinkle,
Yes.
Tony Highsmith,
No.
David Neal,
Yes.
W.T. Patterson, Jane Sowell,
No.
Robert Starkey,
Yes.
Anita Taylor. Mr. President, we have 4 yes and 3 noes. The motion passed.
Council, that just simply requires a simple majority, correct?
That's correct.
Motion passes.
Yes.
Taught me. You taught me, yeah.
We've been in session for almost an hour and a half. Let's take about a 5-minute break. We'll reconvene in about 5 minutes. Let us call our meeting back to order. The next item on today's agenda is to hear a presentation made by Sean Hayes, Ty O'Grady, and Kimberly Teal regarding alkaline hydrolysis. I think you all have been here since the beginning of our meeting. and you all obviously are aware of who we are. We are a board of licensed funeral directors and embalmers, consumer representation. We are a regulatory board for the funeral industry, and we are charged by the state of Tennessee to protect the public health, safety, and welfare by ensuring compliance with statutes, rules, and regulations governing the funeral industry, pre-need funeral contracts, and cemeteries. With that being said, as to who we are, would you all approach the microphone and tell us a little bit about yourselves, who you are, who you represent, possibly what your background in the death care industry is, and maybe what your plans are as we start.
My name's Tyler Grady. That's Sean Hayes and Kimberly Teal. We're here from Chattanooga, and we've been working lately with state representatives and state senators to make it to where the current definition of cremation in the code can be modified to accommodate alkaline hydrolysis. So what we're going to do today is just go over a real brief presentation about what alkaline hydrolysis is, how it works, what the consequence of the process is, and also what various other states have done as far as they've gone about modifying their code to accommodate it as well. So in every instance, about a dozen or so states have already changed their definition of cremation to accommodate alkaline hydrolysis. And in each of those instances, it was an owner of a particular establishment also approaching the board, like what we're doing today. So what we're going to do is just go over some quick information. We also have a handout that I'll go ahead and hand over to you guys. And then Sean is going to present.
These packets are manuals for each of the board members to keep and retain and to be used as future reference for footnotes and further research. It's our ambition in Chattanooga to eventually open in the next 2.5 to 3 years a crematory facility in Chattanooga, which is in Hamilton County. Till is going to be our licensed funeral director. She's going to be attending John A. Hall. With that is going to be our hope and ambition with speaking with you today, the board. We've been directed to you from the State Department of Insurance and Commerce, from both of our senators. We have been in contact with both of our senators and Representative Floyd, who drafted Bill 1125, through communication with him. And as each state has been approached in the past in relation to their legislation regarding alkaline hydrolysis, we come to you on behalf of that same realized hope to be actualized in the future through understanding the process of alkaline hydrolysis as a future method of final disposition in the funeral care industry, and it's what that would entail. I'm going to briefly cover this packet with you, hitting the pertinent points covered under each section, and I would like to spend the majority amount of time, as much as our presence is possible, in dialogue concerning your questions, curiosities, concerns, and further insight. With that, we can start. The sections, the manual is broken down into 3 sections: alkaline hydrolysis process, end products, and state code. And we can briefly go over that as we go along. Section 1, what is the alkaline hydrolysis process? Alkaline hydrolysis has been developed to accelerate the natural process of tissue hydrolysis. This is the same process that's performed in the slightly alkaline soil when people are buried in the earth. Heat is what makes this process practical as a disposition method in the funeral industry. Page 2. Expedited by both heat and agitation to circulate the heated water, the process hydrolyzes the tissue. And page 2 is obviously this same first page, just on the right column. Alkaline hydrolysis accelerates natural decomposition by gentle water flow, temperature, alkalinity, shrinking the natural course of tissue hydrolysis into hours. Dissolved in the hydrolysis solution, the body, already being 65% water, has been returned to its natural form. What is the solution that's used for an alkaline hydrolysis process? It's a solution made up of 95% water and a 5% mixture of 2 alkalis. Both the amounts of the water and the alkalis to add to the process into this chamber are percentages of the body weight of the deceased. The system automatically calculates this with its own weighing cells. What are the 2 alkalis that are added into the solution? The two alkali chemicals used in the process are a mixture of both potassium hydroxide and sodium hydroxide. The mix of these two hydroxides is the most effective realization of the alkaline hydrolysis process to accelerate natural decomposition. With the alkali and water solution combined in the system and circulated with heat, alkaline hydrolysis is achieved. We can discuss the slideshow. The machine has been developed by Joe Wilson in Indiana. This is his technology and the technology that we're going to hopefully employ in the future. The type and model of the machine that he made is fully automated. This large rectangular box is open to a large touch screen so that once the body is loaded in the chamber, you enter the body weight and it configures the temperature for you, alkalinity, automates the process. How the process works is the seal door is open on the front of the machine. A large metal basket is taken from the stainless steel vessel, is loaded onto a table. The body can be loaded into the stainless steel basket, loaded into the machine, the seal door is shut, and the machine is actually, with a wheel, circulated into an angle with a tip technology that the innovator of the machine has created. We'll go in detail over page 3 of the packet. During the process, the solution is introduced into the machine, circulated throughout the system, dissolving the body into water. What makes this happen is a mechanical agitation that the creator made to circulate the heated water and the alkalis. This agitation reduces cycle time by allowing for faster and more thorough alkali access to the tissue material. So with that being stated, alkaline hydrolysis naturally occurs, and it can occur at room temperature, but if it were allowed to occur at room temperature without the circulation and added heat, it would take up to 6 weeks. The method is set up by agitation inside this chamber that doesn't need to be pressurized. And so with each process, the system's loaded, the system's heated up to the correct temperature. The temperature that we're going to be using in this process and the temperature that this technology has been developed to work at is a low temperature model of this vessel, and it operates below the boiling part of water. It's going to operate between 208 and 210 degrees Fahrenheit and no higher. That's the safety temperature to operate at. High enough to and accelerate this natural. After the cycle operates and the body tissue is broken down, that process at 200 degrees, 210 degrees, take 10 hours process to occur. Remaining time would be 2 more hours with a total time of 12 hours for the system to cool down, rinse the remains, discharge, recool the cycle again, and be able to unload the bones from the machine. And we can get to that in just a moment. So, as stated on page 3, operating at 210 degrees Fahrenheit and by optimizing agitation during the process, a 10-hour cycle time, which is a 12-hour turnaround time, can be achieved, allowing for 2 dispositions in 1 day. Page 4, pressure. With this low temperature model, the system will have the highest reliability, longevity, and safety. When we bring alkaline hydrolysis to Tennessee, it is this very model and this very technology that we'll be employing, innovated by Joe Wilson in Indiana, and we'll go over his information soonly. So with this, at this pressure, the pressure of this machine is very low. It operates just above atmospheric pressure with just the added pressure of water. There's no further added pressure to the machine. So theoretically, when the cycle is initiated and tipped up to the angle that's in this bottom left box, the temperature, the machine in the series of the cycle can actually be opened and viewed with no hazardous consequence, operating at such a low temperature. That's a great safety concern. So when it's actually tipped up, the water circulating doesn't touch the seal whatsoever. The water is being circulated toward the bottom of the machine, allowing for higher safety and greater longevity of the machine and safety to the users. And with that, the bone remains are going to remain inside the basket, and they can be easily collected. So this is an actual demonstration that was attended, and with the door open after the process. And this is an actual example of bone remains that are left concluding the process. Page 5. Of alkaline hydrolysis, there's 2 sterile end products. There is 1, the effluent, which is the liquid remains, and 2, the bone remains. To understand these two end products, we're going to have a basic biological understanding that an average body consists of 65% water, 20% protein, 10% fat, and 5% calcium phosphate. Why that's important is because alkaline hydrolysis addresses this composition. The body, already being 65% water and 5% calcium phosphate, it is this 30% of the protein-based components of protein and fats that alkaline hydrolysis addresses. Put simply, water molecules, hydrolysis, are forced through the bonds of tissue particles to break them down, reduce them to their original building blocks and basic elements. So with that in mind, alkaline hydrolysis, what it does with its two alkalis and water moving at this speed, breaks the bonds of all proteins, carbohydrates, fats, and DNA within a body over the course of a few hours, leaving only, as stated on page 5, the end product effluent, the liquid remains, that will solely consist of only small peptides, amino acids, sugars, nutrients, and biodegradable soaps. And the following information describes how each of the bonds of each of the biological building blocks derive these derivatives. There is nothing else left in the liquid remains outside of these 5 derivatives. Also, in the alkaline hydrolysis process, as stated on page 6, the destruction of hazardous presences in the body. All pathogens, fixatives, and toxins are also destroyed in the alkaline hydrolysis process, converting them into biodegradable derivatives as well. What happens is after the machine processes the liquid, it remains in the machine. The machine cools this liquid down with its own automated pH reduction system that automatically discharges this liquid and lowers the temperature of the water into the municipal wastewater treatment facility. Now, both the temperature of the water and the pH are going to be at below neutral acceptable levels as regarded by the EPA. This effluent is sterile and neutral and heavily diluted. Having been sterilized by a multi-stage process by the alkaline hydrolysis system and having been treated in a tertiary wastewater treatment process, there should be the highest confidence in the content of the discharge into the municipal system. With that in mind, we have contact information for assistance with obtaining a permit from 9 other locations that have authorized the discharge of the effluent of alkaline hydrolysis. They are each willing to lend their experience and relationship with the wastewater authorities to commend the adoption of this practice for our city. The other byproduct that is sterile of alkaline hydrolysis are the actual bone remains as left in cremation. These are the solid remains. Outside of the bones, implants need to be addressed. Implants in alkaline hydrolysis do not need to be removed from a body before initiating a cycle. Any implants that are medical support devices actually persist through the process unaffected. After the process, they can be recycled. Common implants that will remain after alkaline hydrolysis cycle are the metal parts to anchor bones, pacemakers, dental implants, and internal prosthetic implants. As stated here, this is an actual picture after cycle rods that were left. Bones, very brittle, dense, and are very fragile after the process once they're cooled down, and can actually be broken up by hand after the process. Concerning the bone remains, all the protein-based materials in the bones, like collagen, are all broken down, reduced by hydrolysis, leaving only pure, sterilized calcium phosphate. The only chemical compound whatsoever that's left over after the process that is not in the liquid effluent is calcium phosphate in any implants that were left over as well. Bones don't have any other chemical or biological composition remaining after the process except calcium phosphate. So after discharging the effluent, the system undergoes a rinse cycle to clean and cool the bone remains. The soft and fragile bone remains are collected from the vessel to be dried and processed using a cremulator to pulverize them to a fine consistency, just as with cremation, to be returned to the family in an urn. The picture on the left is a picture of the bone remains left over from alkaline hydrolysis. The right is after cremation. The difference in the color is that the bone remains of alkaline hydrolysis don't retain any sort of carbon whatsoever. They're an inorganic compound now, calcium phosphate. There's no other foreign material or matter or any sort of other biological presence left in them. Our main thrust of coming here today is to talk about Section 3, State Code. The first subsection of dealing with State Code on page 8 deals with the Cremation Association of North America. The following is vital to understanding that the Cremation Association of North America has suggested that the definition of cremation be revised in order for terminology to be applied consistently by the industry and to encompass various technical processes. Also stated on page 8. In 2010, the Cremation Association of North America released a document entitled Model Cremation Law and Explanation that was approved by its own Board of Directors. Page 9. Stated in the preamble of this document for revision was quoted, "It is the objective of this revised model legislation to present current statutory provisions that will assist those individuals, organization, association, state, and provincial authorities which attempt to enact comprehensive cremation legislation." They dealt with several terminology issues throughout the document. As stated on 9, along the lines of errors attributed to media popularization is the definition of cremation itself. The Cremation Association of North America officially defines, as of this document, cremation. They define cremation as the mechanical and or thermal or other dissolution process that reduces human remains to bone fragments. Cremation includes the processing and usually includes the pulverization of bone fragments. Also explaining from this definition, there are various technical processes used for cremation. This definition was intended to encompass them all without using any descriptive term directed to a particular process. Section 2, dealing with other states concerning alkaline hydrolysis as a form of cremation. Bottom of page 9. 6 of the 8 states that have approved alkaline hydrolysis for human disposition in the funeral industry have updated the existing definition of cremation similar to the revision that the Cremation Association of North America suggested. The first state, Minnesota, added alkaline hydrolysis as a separate process from cremation, but subjected it to the same rules of cremation, stating that alkaline hydrolysis is a form of final disposition. The 3 bullets associated with Minnesota on page 10. The Mayo Clinic in Minnesota, alkaline hydrolysis has been employed in the clinical application of processing human cadavers with alkaline hydrolysis, performing 800 bodies in 6 years. 2 funeral homes in Minnesota, the Atkins Northland Funeral Home and the Bradshaw Celebration Life Center, have been approved for alkaline hydrolysis in Minnesota. Our second state, Florida, altered their definition of cremation to modify by including alkaline hydrolysis in their definition, changing the definition of cremation to read any mechanical or thermal process. In Florida, as stated in the bullet points associated with it, alkaline hydrolysis has been used in the clinical setting since 1995 at Shands Hospital. Shands is at the University of Florida, at the Florida State Anatomical Board, and purchased the first commercial system for disposition of human remains. In 2011, a funeral home in St. Petersburg is using alkaline hydrolysis as a form of disposition. The third state, Maine, also changed their definition of cremation to allow for alkaline hydrolysis, stating that the technical process using heat or flame or other processes that reduces human remains to bone fragments. Also in Maine is a funeral home, the Raposta Funeral Home, that has been operating in an alkaline hydrolysis system for human disposition at a funeral home. The fourth state, Kansas, altered their definition of cremation, changing to allow for alkaline hydrolysis, changing using the phrase mechanical and or other dissolution processes. Page 11, our fifth state, Maryland, altered their definition of cremation to allow for alkaline hydrolysis as well, including the phrase through intense heat and evaporation, including any mechanical or thermal process. Our sixth state in the U.S., Oregon, alkaline hydrolysis was regulated as a separate or alternative disposition, stating that alkaline hydrolysis is a final disposition process involving a dissolution of human remains. 2011, the seventh state, Colorado. the definition of cremation was changed by removing the terms "through direct exposure to intense heat," intending to accommodate alkaline hydrolysis technology. Their definition now reads, "Cremation, or cremate, means the reduction of human remains to essential elements, the processing of the remains, and the placement of the processed remains in a cremated remains container." The eighth state that has officially approved alkaline hydrolysis, the definition of cremation was modified to include alkaline hydrolysis, stating that cremation means the technical process using heat and flame or alkaline hydrolysis that reduces human remains to bone fragments. The reduction takes place through heat and evaporation or through hydrolysis. Out of these other states that have already altered their legislation to allow alkaline hydrolysis as final disposition method in the funeral industry, 18 other states are considering alkaline hydrolysis regulation through their Senate dockets. Places of interest are Ohio, Indiana, and Saskatchewan above us that has already approved it. To move on to the main thrust of our presence is the end, and to conclude on page 12 is Tennessee. In Tennessee, our current definition of cremation, as stated, is cremation means the heating process by which a human body or body parts are reduced to bone fragments through combustion and evaporation. This definition is very similar to the previous other states' prior existing definitions before they were modified, becoming similar to the Cremation of Association of North America model for the revision of the definition of cremation. Suggestion in Tennessee for the phrasing of the definition of cremation is to nominate the last phrase of the Tennessee definition, "through combustion and evaporation," can be expanded to also include alkaline hydrolysis. As stated previously, the terms mechanical and or thermal, other dissolution processes, other disposition method, and chemical dissolution have all been applied to update the definition of cremation to include another technical heating process, alkaline hydrolysis, that will reduce a body to bone fragments. By expanding the current Tennessee definition of cremation to include the process of alkaline hydrolysis would be under the same legal parameters and enforcement as cremation. So, if this is accomplished, when the term cremation is applied in the state code, the process of alkaline hydrolysis will be implied and applied as well. Further suggestion: basic thermal hydrolysis is the phrase that we nominate in order to expand the last phrase of the Tennessee definition of cremation to include, reading that cremation means the heating process by which a human body or body parts are reduced to bone fragments through either combustion and evaporation or basic thermal hydrolysis. On the other hand, another alternative could be to mimic what Colorado did with their definition of cremation by avoiding a specification to a particular process, which could allow Tennessee's definition to remove the last sentence fragment, "through combustion and evaporation," reading that cremation means the heating process by which a human body or body parts are reduced to bone fragments. I'd like to open the voice of the board for questions, concerns, curiosities, inquiries.
Who do you represent?
I represent the personal enterprise to hope to develop a crematory facility in Chattanooga, Tennessee in the future. Represent
Personal enterprise?
ambitious hope to open that facility in Chattanooga. Company. Myself, Sean Hayes, Ty O'Grady, and Kimberly Teal.
Are you licensed as a company in Tennessee?
Not as a crematory facility, not in the funeral industry. We have a business license for Evergreen, that is an LLC, that is going to deal in the future with cremated remains for Chattanoogans to offer alternative ways for families and loved ones to deal with the memorialization of cremated remains. That's where we're at so far as a business entity. It's our hope in the future to expand that business entity to become a crematory facility that is licensed and with a funeral director to operate and preside over all operations.
Connected with every...
No, sir.
You expect your company to franchise?
That would be in our best interest in the future. That is not our ambition as of now. Our ambition is to succeed as a crematory facility in the funeral industry.
In Chattanooga?
Regular cremation.
May I speak from over here, or do I need to go up there? May I speak from here?
As long as
He's
that,
at the podium.
Okay.
I thought we were speaking to him.
Yeah, I don't know. Can I say something?
you want to approach it, you may.
Okay.
Yes. Identify yourself, please, sir.
Grady, partner of Sean Hayes at Forever Green. And so our real intention is just to be able to offer green funerals here in Chattanooga. We didn't mention it at all during the presentation, but alkaline hydrolysis also operates at a much lower usage of energy. Environmentally hazardous rating. So our hope is to just offer a green funeral, a green cremation option in Chattanooga. The main reason why we're here today is just because these machines are $200,000. Business up and running. We just want to make sure that we can actually proceed. We're getting find out we get by some legislation. That's the main reason why we're here today.
Where's it was used to build at?
I was actually built in Indiana.
The city of Pittsburgh.
There's a plant up there now producing them for overseas shipment into Canada and places like that where they're allowed in different states. Okay.
The 5 funeral homes in the United States, final disposition, all 5 built by Joe Wilson, company Bioresponsive.
Absolutely. There's actually a few
Lots
companies.
in England.
Scotland and Australia are 2 of the biggest.
But they're also mainly used for clinical purposes. So it's mostly been used because it's a really, really secure way of reducing any kind of, or decontaminating any kind of biological material. So it's mostly used in clinical purposes for those reasons, and just recently is starting to get integrated disposition methods.
All of these in here, you made a remark about had to tie into the sanitary sewer system of a city. In a smaller city, one of these could not be installed because they might be on a septic tank.
Correct. If the septic tank would be limited, and there another method, another course of dealing with the effluent would have to be.
The reason I'm asking that is in here you state that it, about it being tied into sanitary sewer, and there's a lot of cities. A lot of cities has what's called residential sewer plants only. Can that city accommodate this unit?
Each community has the United States EPA directly regarding output. Output is so if they're if they could not take in these liquid remains, then it would he could not operate on a level by have to be dealt with. So most likely not.
That wouldn't be able to set up to be able to get that.
That's one thing that this board looks at is sanitary sewer connections when you apply for a staff like that. The other one thing that I would like to ask about, and this one is kind of dear to some of these people that's in the crematory business. Can I put Rover in one of them containers?
No, sir. This machine is solely and only built human. Later does build machines for that other purpose, but they're not.
Same process.
But there would be nothing to prevent this machine from doing that, correct? It'd be up to the operator.
Yeah, it could work. It's just, like, there's current state code doesn't permit the same facility to be used.
What code is that? Or what process?
For cremation. Like a standard cremation. I read how to use a the same, so hoping that just by modifying the accommodate alkaline, all the various same regulations govern cremation. Same way.
Clearly stated. Curious to.
This process was allowed in New Hampshire at one time. And after a legislative moratorium on it, can you tell me why?
Oh, ma'am, I can't. By New
What were the
Hampshire's
reasons
legislations.
in those days?
In New York, when the bill was written up, the bill did not include the difference customers' side of understanding of whether or not their loved ones cremated in a retort furnace or used under alkaline. But the bill was written up in New York that is not going to have to be made. Because of that reason, members of the board back up for review. In Virginia, members of the board for religious concerns concerning the nobility of the human body found it to be, for lack of a better term, ghoulish.
The main concern with New York was just, one of the things we also didn't mention is average cost. On here, you authorize me to use either cremation or alkaline hydrolysis. Kind of seemed like it possibly could be an process if full had to modify it and then represent it, as he's mentioned. They're going to do it.
Now, there's already been a bill introduced this early in the game without, and you mentioned that some of the boards in some of these other states had come with opposition to it, but you haven't, at this point, at least with this board, discussed it. Have you discussed it with any other entities beside, say, a state senator or member of the House of Representatives, as far as the Department of Environment, Department of Health, vital statistics, vital records, any of the funeral associations, and obviously today the funeral board?
In originally contacting the parties that we could possibly be introduced to, every single one of those you nominated directed us to the State Department of Commerce and Insurance and directly to the board before proceeding or speaking with them again. So no information.
Before speaking with them again, but not before proceeding through the legislative process.
Before proceeding through the legislative process, both Tennessee state senators and our employed all three commended before any sort of movement that we speak.
I think Representative, by his own initiative, had drafted something. Better.
Speaking of Charles Snyder, who's the legislative liaison for the Department of Commerce and Insurance.
What I'm interested in, I guess, as an individual, and bear in mind, we're not in a policymaking situation here today. We're just in a fact-finding situation, is that if we go down this road, or as we go down this road, to get it right to start with. We don't need to hastily go down a road and then immediately start finding areas that need amending, then changing, needed adapting in any way. We just want to get it right to start with. In my estimation, in helping to get that right and working out some of these definitions, terminologies, and things of that nature, it would appear to me that it might be in the best interest of all if we were looking at, it is a means of final disposition, or a means of disposition, not final disposition, but a means of disposition. So in some ways, they are akin to each other, but they are other means of disposition as well, where you have apples and oranges. They're not all apples in the same basket. So I would be interested in looking at alkaline hydrolysis being a tub, if you will, that sits on its own bottom, and cremation in one that sits on this. I'm not for sure that redefining the word cremation is what we need to do to make this happen. It just would appear to me that each of these, that there would be nothing wrong with two different headings, a heading for cremation, a heading for alkaline hydrolysis. Then if, who knows, in the very near future, they may be a third or a fourth. And I could envision some of those myself, but we just want to get it right to start with.
And that's actually a route that a couple of states have taken as well, just giving it its own tone.
I think as it is drafted, that obviously the environmental departments would need to have a seat at that table. The Department of Vital Records, record-keeping would, especially if a definition is used other than piggybacking on cremation. For instance, I can't picture that death certificate. Does it say other, or does it say burial or cremation, or that might need to be looked at, things of that nature, which is a process that they would need to be involved in.
Piggybacking alkaline hydrolysis with cremation can be viewed in a positive light as well, though, with the amount of regulation that's brought forth before the board continually and enforcement on frequent, recurring, dealt with in such a way alkaline hydrolysis can be dealt as strictly as responsible by a standard authority attributed, filling it on its own by a living history, ups and downs. God will present its own.
Never used the bile cremation.
That is a term registered by a developer. Other popular terms that have been used to nominate this process that have been registered names are biolife, rhizomation, aquamation.
You have some concern that where these mechanical prostheses and things are attached to these bones, and I know in cremation we take every means possible to retrieve all of the cremated remains. It would seem, do those bone fragments readily turn loose of those prostheses?
Very much. Yes, very, very readily. You with
not any residue that for instance, that last slide, please, ma'am, there, to get those medical components outside of that bone, how would that take place right there?
There is no bonding between that metal and that calcium phosphate shape. Biological or chemical material left between them.
Plastic.
What I was going to ask.
Plastic would survive the sterile process, and it would not be broken down in any sort of way. It would just be sterilized.
A lot of knees.
I'm looking at that set of dentures.
Only organic matter is broken down. Only protein-based material.
Basically, this is like burying somebody right in the ground and digging them up 100 years.
Correct,
they
yes,
come
sir.
back. Just accelerates it to a 12-hour process.
What is it? What are the active? How can we make it happen really quick?
How big a person can you put in this chamber?
The machine that we're going to acquire is 610 pounds. Other machines have a higher weight capacity, but that's the one that we're going to acquire.
610, go ahead, I'm sorry.
Yes, sir.
Go ahead.
That machine, could you put a 600-pound body in there?
Yes, really.
In that basket.
Have
that
some
cylinder.
shrink wrap to do it.
Vacuum.
Because that cylinder
I don't
doesn't
think I'll fit
appear,
in there.
that cylinder doesn't appear to be much bigger diameter than the man standing in front of it.
Yeah, just open that cylinder.
Like an optical.
That athlete probably weighs about 260 pounds. He was a professional. We actually have him easily fitting in that basket in pictures.
That's a long way from 610 pounds.
There's different model sizes of the same machine, but the model that we're going to be possessing would accommodate the larger body weight.
I noticed the other one had the fan there. Is there a lot of odor with this process?
There is odor, but it wouldn't be the sort of noxious, bothersome type.
Like a decomposition odor you'd be smelling go into that room.
Because before the seal is ever opened again, it's sterilized, rinsed 3 times, and discharged before you would open it. No leaking. Gas
Health
liquid.
hazards for the employees taking those bone fragments out then.
Correct. It's already completely sterilized in the form that the family will
Not the line
handle it
left in those bones.
time they open it.
It's sterilized. I noticed the ungloved hand. That had the
Correct.
bone.
Yes. Before the machine is open.
Mentioned earlier that the way it was tilted, that the lid could actually be opened during the process.
Yes. You wouldn't want to, but theoretically, for safety, non-hazardous concerns, yes, it could be.
If that were the case, would any emissions come from there that would be biohazard?
The water level that it's circulating at is far below the seal. What it's doing is circulating on the bottom half. That's why the bones all.
This process, there's a low pressure and a high pressure.
Correct. The machine that we're advocating in low pressure, which operates at atmospheric pressure. Talking in this room. Vessel's not pressure. The reason the high pressure vessel exists is because it would operate at a higher temperature. It would operate over the boiling point of water. It would operate far beyond 200 degrees. It would operate even beyond 300 degrees Fahrenheit. Because it's boiling, for safety reasons and the maintenance and longevity of the machine, have to be pressurized in order to accommodate that.
Quicker process.
Very much quicker.
4 hours if you go high pressure.
Very much quicker. Half or less than half.
Those also have a process of locking.
Once you get a low pressure one, you looking to get the high pressure one then?
high pressures too.
Any other questions for these gentlemen?
Smith,
Yes, sir.
can I ask a question?
Yes, sir, absolutely.
What about the discharge? I noticed it's 3 times the body weight. Is that correct? If you have a 100-pound individual, you'd have 300 gallons of water? Or is that
300 pounds.
300 pounds, not 300 gallons, but 300 pounds?
But that would be the theoretical amount of water if the vessel were not tipped. Since the vessel's tipped, require a lower amount of water. Probably going to
Do you anticipate any problems from environment and conservation regarding discharge?
not whatsoever. No city that is been in communication with its own municipal water system has been thwarted on this issue of the effluent discharge. Each one of them, each municipal place has its own regulations of the temperature of water that can be accepted and the pH of the water. And this technology has been developed to fall far beneath both those regulatory standards across the United States. Are going beyond the required temperature.
Never met Joe Wilson.
Just be discharged back into the wastewater system.
EPA neutral pH is 12.5 on the pH scale. Most temperature regulation of what the temperature of water that can be emitted into a local municipality this is going to fall to 140 degrees, far beneath what's required. Many commercial, industrial entities dump all kinds of high water level temperatures.
What about maintenance of the machine?
The machine's developed to last 50 years. It's not pressurized. The longevity and the investment in the machine is going to be
High pressure machine.
circulating at such a low temperature and low pressure. Loading and unloading. Stainless steel con.
We have field representatives that go into each establishment and do an inspection on an annual basis, and when they go to a crematory, then if that company who manufactured that has been in and done some work to the crematory, then they leave some information, a data sheet that shows what work they did and when it was done. I guess that was more what I was wondering. Is, like Mr. Wilson's company, do they envision some type of inspection on a 2 or 3 year basis, or?
That is a very good question. He wants to take his technology as serious as he can for his own survival, and he has been intimately involved with each of the 5 funeral homes that he's installed and stayed in direct contact with them over the course of all of their dispositions. And he would most likely want to, maintain that relationship with us as well in the future and be responsible for the machine for his own company's sake. So they would install the machine themselves and give it its maintenance without requiring a third-party intervention. And I think it would be to his best interest, and I think that he would agree that he.
I guess, if a funeral director were operating it, what would notify them that it's not operating correctly? Is there some kind of, in that panel?
Yes, the automated technology of giving it all its calibrated calculations with each disposition can be checked at any given point in time, and it has its own maintenance update, similar to a car panel indicating of an engine problem. He has these sorts of installations involved in the automation of the machine.
And a warning or some kind of bell?
Right, yes, sir, correct. Yes.
Light indicator or something to show you what
exactly
functioning correctly.
What that is.
On that piece of equipment, would you would the individual be trained to operate that unit?
Yes, sir. The developer of the technology, Joe Wilson, he and his staff would, they themselves, give the instruction. That's what they've done so far, and each of the states have accredited that training to accommodate it.
We're looking at an individual that would be employed there that would be, I'm going to use the word certified to operate that piece of equipment?
Correct, yes, sir. And if so needed, to be further accredited in any sort of state crematory training as well.
Low pressure is a 12-hour process. So once you put that in, you'll leave and come back in 12 hours then?
Well, you would come back in probably 11, and you would use the rest of it, unload it, process them. That would complete the 12-hour time. I wanted to include all the physical so that you could do 2 full dispositions in one.
I think state law now requires the funeral director to be present during the whole operation of the crematory, so you'd have somebody there 12.
Yes, sir.
Use
Not
the
a
same,
helper, but a funeral director.
same type of processor.
Yes, ma'am, the exact same machine. The same cremulator pulverizer that once you remove the remains from a process them.
Would you use the same one for both procedures? I see this system side by side of
Yes, the funeral home in Maine and in Florida both have their hydrolysis vicinity, and
they use the same processor for each procedure.
I wouldn't know that.
What would the estimated cost be to the consumer, or do you know what they are in other areas?
We would make it along the lines of direct cremation process.
A wide range.
Yes, sir. It could be a wide range, right? Operating expense.
In the spirit of cooperation, in the remarks that I have made and that you have made, outside of us maybe seeing differently cremation versus alkaline hydrolysis being 2 separate entities or 2 separate rules and regulations, do you see any other differences that you and I would have?
Yes, sir. If they're made distinct, it just goes along with that and be implied that if they are 2 distinct processes, then it would seem to be some sort of state regulation would have to be created for the type of facility that would accommodate alkaline hydrolysis. Since there's specific crematory facilities that do not do burials, what type of further distinction operate alkaline hydrolysis, and if so, solely only alkaline hydrolysis?
If we were to go down that road, do you see an effort of cooperation on our parts to still make the end result happen with some adjustments on both sides? I mean,
I don't see any. Yes, sir.
Any other questions before we hear from other interested parties? Let's do that now and open the floor to any other interested party that wants to address this subject. And I think on the agenda, Mr. David Murphy is to be recognized, and then we'll see if there are others.
Chairman and members of the Regulatory Committee, my name is David Murphy, Murphy Funeral Home in Martin, Tennessee. I'm certainly not an expert on alkaline hydrolysis, cremation, or burial, even though I've been doing it 50 years. I have served on this board 2 terms, a total of 8 years, and I think that gives me a little bit of background to make some comments on this. I first want to compliment these people for their presentation. It has helped me, and I'm sure it's helped you. I feel if this presentation had been made prior to the law being introduced, it would have been more advisable, but it was not, so we're where we are. I read this bill, it does redefine cremation. It piggybacks the laws that regulate cremation, and if it is passed, it's retroactive till January the 1st of 2013. I believe I'm correct about that. I think and I may make reference to departments, professions, groups. I'm not speaking for these people, I'm speaking for me. But I think in the people I've talked to, you will find the prevailing sentiment with us that are licensed practitioners is that this is two separate processes. There is cremation and there's alkaline hydrolysis. The fact that it's dealt with in the same tone in other states, I don't know that's relative to me. I go back to a period when cremation in the state of Georgia, specifically Noble, Georgia, was dealt with apparently under different rules and regulations than we had, and it didn't work out too well. I think that this needs to be a partnership. I'm not against this law. I'm not here to say that. But this law needs to be a partnership between, and Tony, you related to this. It needs to be this department and this board. It needs to be the environmental people. It needs to be vital statistics, both in death certificates and cremation permits. It needs to be the Tennessee Funeral Directors Association, which are practitioners like myself, and nobody, well, the consumers have vaguely been mentioned, but they need to be involved in this too. And the only way that can be done is for these groups to come to the table in common cause and common discussion and be sure the intent of this law, the wordage of this law, and the spirit of this law is where it should be. The way it has been presented, and certainly I don't want either of you or the sponsors, House or Senate, to take any of my statements as being abusive or abrasive in any way. But it's been presented in a way that takes it through in a fast rate. And it pretty much abandons the rules or the process that laws become laws. They don't go through fast. When they do, they have to be redone and have to be re-amended, and that's not healthy. The danger I see in this, if this law is passed as it is today, and I'm going to make a couple of references here. I came up with a law that regulated banking. I could make it more consumer-friendly than banking is for all of us. I imagine the banking lobbyist and group would come to me and say, Murphy, let's discuss this law before it comes before the legislature. If disposal of human remains goes through as it is, if the rules and the regulations, the laws that govern it are compromised, what's to keep someone from coming back to this group next year and saying, I, as a licensed practitioner, have partnered with a waste disposal company, and they're going to provide me body bags, and they're going to pick up human remains at my facility 4 times a week and dispose of them. That is bizarre. That is ridiculous. But if you compromise the laws and the rules and the principles that we operate under, you're not eliminating that, because it would put that person in the position of saying, you piggyback, you opened it up for alkaline hydrolysis, open it up for us. It sets a precedent, and it's a dangerous precedent. And to these gentlemen, I respect your opinion, I respect your cause, I hope you do mine. They have stated that there is not a licensed practitioner or a licensed establishment involved in this at this point. They have a program for one, but not at this point. I think by the nature of that, it weakens your knowledge of what we do. If you were licensed or you were a practitioner in our business, you would understand our side of it. I think those are valid reasons. Again, if I've said anything that's abrasive or offensive to any of you, I apologize for that. Those are just my basic common sense feelings. And I realize that common sense and logic don't always apply with legislation. Thank you.
Any comment from the board regarding Mr. Murphy's remarks? Any questions for him?
Could I ask Mr. Batson, who's present as the representative of the Tennessee Funeral Directors Association, is there any plan for these gentlemen to make a presentation to the Tennessee Funeral Directors Association and have other entities as well involved, and then possibly from that having just what Mr. Murphy has suggested, everybody sitting down at the table?
Ms. Allen, Mr. President, members of the board, haven't heard of any. First I was contacted about it was out there. What was going on? I would like to say to these young men and ladies, of the National Council 2010 heard several nations alkaline hydrolysis, but talking about coming in. As far as TFDA is concerned, I haven't spoken with anyone that is against the process. As a matter of fact, it's a national issue, and it's becoming more of a national issue. The only issue I have with it is very similar to what Mr. Highsmith and Mr. Murphy have said. Get it right the first time. I'm still of the opinion that they're two separate, cremation and alkaline hydrolysis are two separate issues. Maybe it's just my old brain, but fire and water, that's pretty much what this is about. And I don't think those two statutes would mesh. To be wrong, there was I believe in 2012 in Ohio, there's a guy named Jeff Edwards, and I've heard him speak a couple of times at these national organizations. Go to end this process, and then the state government let him quit. It's not an authorized form of disposition, and I believe in 2012 the court upheld that decision that the states had that right to regulate, and it all boiled down to it's an authorized form of disposition. And as of now, even if it says other, this is not included. So it becomes a process for the regulatory agencies to define this as an authorized form of disposition. And there are several steps that go with that. There are several departments that are involved with that. And had we heard about this beforehand, we could have avoided some of these conflicts that seem to be happening. However, it's not too late. I just don't want to give these young folks any promise that happened this year. Matter of fact, TFDA's position is we would like to postpone it for a year to have these issues worked out. Is it going to stand alone? Is it going to be in other regulatory, in the cremation laws? How is this going to be handled? Is it going to affect the death certificates? The EPA folks are involved in. That's the kind of questions that we want answered before we could endorse this. As it stands now, we can't endorse it for that reason, not because of the process or the procedure or the act itself. It's just the implementation. We're very much, like I said, this is a national issue. I mean, as a state, we're going to have to deal with it sooner or later. So we might as well deal with it right the first time. It's less than a whole lot of problems for anybody. But again, congratulations, guys. It was well done.
Thank you, Mr. Patton. Any questions, Mr. Patton? Legal counsel, do you have any remarks, please, sir?
No, sir, not at this time. So.
In the effort to move forward and in the spirit of cooperation, I guess my question would be, would you all support the idea of pulling the bill for further discussion and moving forward in a cooperative effort with all of the parties at the table?
A cooperative effort would seem to be advantageous for the multiple state entities to talk about and to be on the same page about. But this not being a law created out of a void of a creative place from nowhere, this is already a serious national issue that's already been addressed by the Cremation Association of America, North America, to initiate a comprehensive definition and defining of cremation to include processes that are already being put in place. And this cooperative effort seems to be the noble direction to go, but on the other hand, the direction that it's already going in is already in such a way that we are approaching the board the way that other state boards have been approached, as a single entrepreneurial entity approaching their state board for the sake of this process. We are mimicking the same way that it's already been adopted. The other state boards were not approached in a cooperative fashion by their other local state entities to have this put in the place of funeral homes.
And I think you would have to agree that your approach to the state board was after the fact.
Actually, like I mentioned, the main folks we were working with were Todd Gardenhire, Mike Bell. Who were the representatives? Was it
Richard Floyd was the name.
Floyd? He was one of them, and another House representative, whose name slipped my mind right now, but we weren't even aware that Representative Floyd had drafted a bill and submitted it. So we thought we were working mostly with a couple of other guys. So we actually just found out that he advanced something earlier today. But just as far as the spirit of cooperation.
You know the origin of that? You know the origin of that?
Of what?
What precipitated Mr. Floyd proposing this bill?
Oh yeah, we talked to him and
Made the initial contact?
Yes, ma'am.
yeah, we did. We didn't know he actually drafted anything, or he didn't contact us again after he presented anything or talked about his progress. So we were actually really surprised.
Didn't have any questions about anything after talking with you one
All
day?
the other guys we talked to did. That's why we were really surprised when we saw that Representative Floyd's name was on it. Yeah. So, but yeah, as far as cooperation.
Who's the other sponsor? Have you talked to that person in the House?
I believe it's Mike Bell is the one I imagine, but Todd Gardenhire was also pretty enthusiastic as well.
But you haven't talked with either one of them?
Oh, well, no, we've spoken with them.
Several times.
Yeah, we just haven't spoken with them probably in about a week and a half or so. But as far as the EPA goes, we did speak to the EPA representative for the region. They said ultimately it was within the guard of local municipalities as far as inspecting of the effluent or the output goes, which is part along the lines of getting the permits, all that kind of thing. So it's kind of a regional thing. Most of the other laws did make a comprehensive revision to accommodate alkaline hydrolysis as its own separate animal. They didn't make reference to the EPA within the context of the new code that they wrote. I don't recall making a specific recommendation about how vital records should regard it either. So those may be small issues that we can work out. I know that like whenever somebody encounters a new thing, if you have a few questions pop up, you're like, whoa.
What
we're rushing it.
committees will hear this legislation?
What committees will hear it?
The General Assembly, what committees will this legislation have to sanction by?
Do you want to answer that question?
I'm not aware of which committees would be.
Murphy, if you approach the microphone, please.
What I'm hearing right now, I think, magnifies what I just said. We're getting piecemeal comments from, I think, I suppose, maybe. There's too much. This is not black and white. This is too much gray in it. And you made the reference yourself. There's nothing better than a good bill. There's nothing worse than a bad piece of legislation that has to be amended and redone and countered or bring it into a turf war. And respectfully to these people, I would make the same appeal you did, that if they would take this bill off the table for a year to allow these people to come together in discussion and make this a partnership bill. You'll have a good bill if you do that. If you don't, you've got a problem. Thank you.
I think you gentlemen obviously know what you're talking about because you've made me understand it to a certain degree. But I don't understand how somebody could propose a bill involving circumstances of this nature without coming back to you and being sure and saying, now, all right, we've got this. I'm going to have to go before the environmental committee. I'm going to have to go before this committee. See that it gets through. I mean, you're the experts. Why wouldn't they be in touch with you and have you there to appear before these committees? I believe. Who said you were contacted by a lobbyist? Mr. Batson, did you say you'd been contacted by a lobbyist?
No, I haven't. I just heard it. Yeah,
Somebody said that.
Our lobbyist mentioned it, that there was a bill concerning alkaline
Lobbyists
hydrolysis.
for the Tennessee Funeral
Yes,
Director.
exactly. And that's the first that I'd heard of it.
Are you aware that it's scheduled before any committees of the General Assembly?
I'm not aware of any, and I have spoken with Senator Bell about it, and he is willing to, of course, listen to both sides, but he's also said that he had a constituent that had a bill that he wanted to get settled, so to speak, but he is willing to work, and I think Senator Bell has spoken with, Robert, did you speak with him, Mr. Group?
Yes, Charles Snyder, Benton McDonough, and I met with Senator Bell, Representative Floyd, about a week or 10 days ago?
Yeah.
To answer whatever questions they had. As I mentioned earlier, Mr. Snyder is the legislative director for the department, and he scheduled a meeting with, or the meeting was scheduled, and we were advised of the meeting, so we went and met with them. And I think what Mr. Batson said is very, very true. They're open to the idea of input, but at the same time, they have constituents that are wanting a bill that's passed, and so they're concerned about passing the bill for their constituents.
Comment on what you addressed, Ms. L. The way that Richard Floyd wrote the bill is the way that we proposed the bill to him, is the way that we presented it to him was our desire. He said that he would back it. Senator Bell said that he would back it. They said that they would put it as their bill that they would promote on behalf of the Senate docket. And at that point in time, it seemed to be that any more exercise of our own influence or power was that was the conclusion of our relationship. That they said that they would back it, that they would make the bill the way that it's proposed, that they were pleased with it, and that they wanted to proceed with what we presented them with. And at that moment, I'm not aware that we were involved in the process any longer to, on their behalf, to speak to a committee that would vote on the bill, consider the bill.
They didn't give you the bill to review before they proposed it.
Conversations and the presentations that we had with them, we answered, just like we answered several of the board's questions over the course of time of multiple interviews and multiple conversations, settled the issues that were pertinent, and asked conclusively is what other sorts of concerns were left, and there was, I'm not aware of what else was to be addressed after the end of our conversations with them, when they decided that they said they would back it.
Effort to wrap things up today, is there a summary statement that the board would like to entertain, or do we want to take a straw vote as to whether, what our opinion is as we go forward? What's the will of the board? Is the board of the opinion that this should go forward in the manner that it has been presented, or is the board of the opinion that, as has been stated by at least one or two of us, that these need to be separate entities, and that cremation and alkaline hydrolysis need to be approached in two different areas.
It needs to be approached in two different.
I think it needs to be approached in two different areas. I think there could be common ground in the, at some point, is if it comes under all the same regulation, so wouldn't have to change laws, separate them. Been working on cremation several years and keep improving it, or trying to, then you're almost got a separate area. If you're going to separate it over here, then you got to make sure you've crossed all the T's to get back to where we are right now with cremation. So I definitely think it needs to be separate, but under the same laws that govern cremation, all laws would govern this. So, because we've been working on those for a number of years, I think it's just another way of disposition. I think shooting people into space has become another way of disposition also. So, there's, as we said earlier, there's, and David Murphy said, next year something else is going to come up. So I think it needs to be defined, as far as Tennessee is concerned, a method of disposition. I think it does need to come under laws, as are all the laws, govern it.
Any other comments? Yes,
we need to end it. Most of our time on bigger deal than most people think, because
I think the question that was posed earlier, too, that the gentleman brought up, is it definitely needs to be defined on the forms for the general public, that they realize that mama's going to be this, or mama's going to be cremated or burned or watered, so it's not, if you just attached it and it would almost give the funeral home or the person the option of doing whichever they wanted. That's the method. If you choose cremation, you don't bury your mama, you might bury her ashes. But if it's a form of disposition, burial is a form of disposition, cremation, hydrolysis is another form of disposition. So shooting to the moon is another form of disposition, Burying them in the backyard without anybody knowing is another form of disposition. So there's a lot of what ifs here.
I buried them when people knew them.
Let me say this, and this, I'm a retired building official and city planner, and I can tell you that if I was sitting watching a new zoning ordinance or something go through, it would scare me to death, because there's no, all departments have to be together when you do stuff like this. And that's why, this is, and I agree wholeheartedly, this is just another way, and there'll be more ways than this that will be reviewed over the years to dispose of a human body. But that's the one thing that I have is, you got a bill that, did they delay the vote on it the other day simply because they ran out of time, or was it next?
Oh, that's different. That's a different bill.
Okay, I misunderstood.
This bill, I think part of the movement, there's not been a lot of movement on this bill in the last few days, and part of that may be for them to come and make their presentation today to the board.
And that, like I say, that my boss would kill me if I really tried to get something through like that.
Any other comments? Is the opinion of this board, are you in favor of House Bill 1125 and Senate Bill 1338 proceeding as they are you of the opinion that further discussion, further meeting needs to be held, and redraft legislation in either a compromising or another direction?
I would suggest the contact with the proposing legislators or sponsors of the bills in the House and Senate and ask them if they would entertain delaying it. I know you want it done as fast as you can. That would be to your advantage. But in order for us to have this spirit of cooperation that I think would be beneficial to you and to the consumer, we need to have some more discussion about it. And if it could be put off, because this first I knew about this was when I got an email about upcoming legislation Friday, I believe it was.
Ms. Hall, does that come in the form of a motion?
If that constitutes, what I've just said constitutes a motion, yes. But I really think if we could do that in conjunction with TFDA, with other interested individuals such as Mr. Murphy, and then our department heads could get with other department heads and see if that's that would be involved. Department of Environment, the Department of Health, which certainly would involve the permits involved for the process, and then the issuing of a death certificate prior to that. Distinction needs to be made on the death certificate. Add the term alkaline hydrolysis. Make the two, or is it getting off cremation? Those things need to be considered, as Mr. Murphy and Mr. Batson, and I think everyone here is in agreement. You want a good bill, and you want something where I think it'd be good preventative maintenance to on the rates just a little bit, and let everybody have their act together.
Can that come in the form of suggestion, or does that need to come in the form of a
formal motion on that?
Ms. Sowell, will you entertain that as your motion?
Yes,
The
sir.
suggestions you have just made. Is there a second to Ms. Sowell's comments there?
Second it.
Second, Mr. Hinkle. Any further discussion as far as it being the opinion of this board to adapt Ms. Sowell's suggestions? It's been seconded by Mr. Hinkle. Any further discussion?
The motion include direct Mr. Gribble to make these contacts.
I think
And
when you said
express
that
the-
it would come from this office,
Express the,
this department.
I think Mr. Gribble's already met with them and
Yeah.
the attorney and things. Should the motion include, we do not accept it as presented, we do not accept with this legislation as presented, then we need to add other things.
Move forward with full cooperation of all of those entities that you discussed.
I'll add that we also include FSD, SFD.
I think that's understood in the word associations, funeral associations. Any other discussion?
Are we allowed to make any more comment?
We've got a motion on the floor and a second that we need to take a vote on. Other discussion from the board? All in favor, say aye. Aye. Any opposed? Yes, sir. Do you like
No, I was just wondering, I don't know if it's too late now, but I know that one thing that some states have done is they've actually just done a definition change early on, and then they ended up doing the larger change that you've recommended. And I was wondering if something like that could be viable to start with, because when somebody orders one of these machines, it takes the guy about 5 months to put them together, anywhere from 5 to 8 months.
That's what I hope would come from
Yeah.
this
So I wasn't sure if we could,
conglomeration.
because it's going to be hard for us to get like a loan from a bank if we don't have legislation supporting us.
I don't think that, from what was said today, that this board is in support of redefining the word cremation.
Because I was wondering if what we could do is just do that as a temporary kind of thing, because we're not going to be up and running for a while, and then in the meanwhile, do some more meeting and collaborating so that we could just get things in motion.
If you spend a lot of time on it. So that's where I'm concerned is they're not educated on it, and they're going to say, well, why don't y'all go up there and pass that? And I didn't know anything about it.
Would we have the opportunity to assist in education, in presentations?
Yes, sir, you would need to contact either of the funeral associations, and
Pretty good
Mr. Batson
programs,
could- Mr. Batson could, any of us could tell you who those people that you need to contact are.
That's the meetings coming up.
Mortician Association, all involved. Board will entertain a motion to adjourn.
Motion to adjourn.
All in favor, say aye.
Aye.
Thank y'all so much. Great job. I understand it now.
That's all right. Just give me a minute.